So, to this person on the device just labeled Mac, would you be Stephen Smith?
My Christian appellate name is capital S, lowercase T-E-P-E-H-E-N, capital S, lowercase M-I-T-H.
Okay, so that would be a yes. Thank you. Deputy Sims. Now calling 24W003208A, the Township of Ypsilanti versus Stephen Cameron Nigel Smith. Deputy Sims, state your name for the record.
Deputy Sims.
Thank you. Okay, and Mr. Smith, you've already stated and spelled your name out. Thank you. Today is the date and time set for an informal hearing in this matter. What I have is a citation issued November 17th, 2024, that charges that on or about that date you did operate a motor vehicle on Holmes Road at or near Ford Boulevard. And when you were pulled over, you failed to disclose to the officer that you had a concealed pistol and a CPL.
If anyone ever needed a reminder of why the Second Amendment exists, this situation explains it well. There are people out there who believe they're above the law and act like legal rules don't apply to them, even while carrying a weapon. That combination can easily create dangerous and unpredictable moments for everyone around them. It also shows why responsible behavior matters so much. Situations like this highlight the need for proper enforcement and awareness.
So, it looks like you were also cited for having a window tint. I don't have that citation, which presumably means that it was paid. So, again, this is a civil infraction. There is no criminal penalty associated with this, no jail time, no probation. There is, however, a fine. Before we get started, Deputy Sims, was there anything that you wanted to say?
No, ma'am, I'm ready to proceed.
Mr. Smith, as you have likely heard already, you have three basic options when it comes to this citation, and these are your three options. You can accept responsibility, that is basically admit that you did not disclose per MCL 28.425F that you had a license to carry a concealed pistol and that you did not present that immediately to the peace officer when you were pulled over. You can accept responsibility with an explanation so the court can take into consideration any mitigating factors and potentially lessen or eliminate the fine. Finally, you can deny responsibility, that is, deny that you failed to disclose your CPL immediately, at which point we will proceed to the informal hearing. I will swear in both sides, take testimony, and make a decision based on preponderance of the evidence. Which of those three options are you going with?
I want to, may I grant my name to the court and make the court trustee?
The court's job is simple. It acts as a neutral referee. It is not there to serve as someone's lawyer, assistant, or personal manager. Sovereign citizens claim otherwise because they believe the judge is somehow tied to their financial accounts, which would create a conflict of interest. If that were true, every judge would have to step away from the case one by one until no one was left to hear it. On paper, it sounds clever, but in reality, it falls apart immediately. The legal process just doesn't work that way, and courts don't operate based on imaginative theories.
But the option 3, as your question, I deny responsibility and I have an explanation.
Okay, so if you are denying responsibility, then I'm going to swear you in and swear in the deputy, and I will take testimony from both sides. So let me explain how this is going to work. After I have sworn you both in, I am going to take testimony from Deputy Sims first, because Deputy Sims is the officer in charge of issuing the citation. That means he's basically the plaintiff. in this matter. Okay. Once he has finished his testimony, which you are not to interrupt, it will be your turn to testify. He is not to interrupt you either. After I've heard the testimony from both sides, I will make a decision based on preponderance of the evidence. As I stated before, that is a 49% to 51% standard. So basically, whoever's testimony is slightly more persuasive. This is not a criminal case. It is not beyond a reasonable doubt in this situation. So, do you comprehend everything that I just said?
I do comprehend.
Thank you. Okay, raise your right hand, Deputy Sims, and Mr. Smith, you will have to tell me when it's raised if you're not turning your camera on.
It's raised.
Do you swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth to the best of your information, knowledge, and belief, Deputy Sims?
I do.
Mr. Smith?
Yes.
Thank you. Okay. Deputy Sims, you may proceed with your testimony.
On 11/17/2024, about 3 a.m., my partner and I observed a black Ford Fusion. It was on Ford Boulevard. I believe it had just turned onto Ford Boulevard with tinted windows. Proceeded after the car. It turned into the gas station there on the corner, and we followed it into the gas station and proceeded towards one of the exits. Before it returned to the road, the driver, Mr. Smith, exited and began yelling at us. At that point in time, we activated our emergency lights and conducted the traffic stop there. We made contact with him, explained the reason that we had followed behind him. And when I approached the vehicle, I looked in the vehicle and I observed a firearm on the passenger seat. At no point in time during that did I hear I have a CPL until after the firearm was located. He was detained, his CPL was verified, he was issued the citations and released.
So that wraps up the officer's testimony. It was pretty direct. He stopped the driver, and the driver did not tell him that he had a CPL while carrying a hidden handgun. Michigan law, under MCL 28.425B, clearly requires people to disclose that information during a traffic stop. In a normal situation, a trained attorney could build a solid defense strategy based on the details of the case. But instead, we're about to hear how someone trying to defend themselves without legal experience attempts to explain it. And as you'll see, this usually leads to more confusion than clarity. It's a reminder of why legal advice matters.
Mr. Smith, it is your turn.
I want to mention there's no damaged property or victim under sworn oath. Also, I believe I was being racially profiled. I had been pulled over, which I did stop, and I was let go because I wasn't suspected of any crimes, just as I wasn't suspected of any crimes by him as well, as he mentioned. We had sat in the intersection, which I was in the middle of a DoorDash, and I wanted to get on my phone to see where I was at. When I looked away from my phone, I seen him, the officer, and another deputy, or whoever it may have been, an officer, also sitting in the middle intersection for about 30 seconds, maybe to even 60 seconds. So he could see me through my windshield. While I believe it was racial profiling, considering the area we were in wasn't the best area. So when I pulled, which I did use my turn signal, and it was a stop sign, or it was a light, a signal light. So when the light turned green, I turned right with my turn signal. I also turn signaled into the gas station, which I was going to stop to check my phone because, like I told the officer that had pulled me over 10 minutes before, which I'm sure he heard on the radio call, I was door dashing, which I had admitted to both of the officers. He called another officer in response to what he calls me pulling myself over. He never admitted to pulling me over. He said I pulled myself over. I got out the car to explain myself that I was door dashing and that I felt like I was being harassed because I was just previously pulled over. I did not have a firearm on person, and he didn't have a reason to suspect me of any crimes or try to search my vehicle. I was illegally searched on person without my disclosure. I told them I don't consent to any searches, and they were digging in my pockets. I have a legal license, and I'm not suspected of any crimes. So
the stop happened because the officer suspected a violation, specifically illegal tint on the front windshield, just as he explained. That's what led him to pull the vehicle over. The driver insists he was stopped because of his race, but later in the video, he admits there actually was tint on the windshield. If the officer couldn't see inside the vehicle because of that tint, then he wouldn't have even known who was driving. That's why the claim doesn't really hold up. It's important to stick to the facts of what actually happened during the stop. Clear details always help the truth stand out.
After he said I pulled myself over, he flashed his lights and they kind of like grabbed me up, and I feel like they assaulted me in a way. And after he figured out that I did have a CPL disclosure, which he never gave me time to disclose because it was not on my person. So I didn't feel the need to, because I was not present in my motor carrier for him to be in any type of danger. After he sat me in the car, which I feel like I should not have been detained that way, for about 15 minutes, they let me be on my way with a citation. And I don't believe I deserve the citation. And he doesn't have any evidence of the situation. It's just a presumption with no material.
Does that conclude your testimony?
Yes.
And did you have any evidence or witnesses that you wanted to present?
I have evidence on my phone of me asking him, what their badge numbers was, which they didn't really want to disclose. So I had to look it up on the internet. I have a dash cam, but it was not running at the time.
So before we continue,
In that last part, he gave one solid point and one weak one. Starting with the weak point, he shouldn't base his entire defense on the officer's claim about why he initiated the stop. There's no video or audio to prove it, and even if there were, it wouldn't change much. Having tint on the front windshield is illegal in Michigan at any level, which already gives the officer a valid reason to pull the vehicle over. Now for the stronger point. They never tested the windshield for tint, meaning he could argue that nothing was officially confirmed. That could help with minor violations, but it still doesn't remove the other charges he's facing. A partial fix doesn't erase the bigger issues.
I want to apologize because I did actually have the equipment violation citation as well. That is for the window tint. So did you wish to address the window tint specifically?
That's just how the car came. I bought it that way, straight from Ford. So it's free.
In Michigan?
Yes.
Deputy Sims, since I don't think I specifically asked you about the tint either because I had misplaced this on my desk, do you wish to address the window tint?
Yes, ma'am. I'm sure you're aware that no vehicle that comes from the factory has front window tint on it. During his first testimony, he admitted to having window tint and said that we saw him through the windshield, which is not possible at night, but he admitted that there was tint.
May I add something?
You may.
There's they didn't test any window tint for any type of darkness issues or anything like that. It was just kind of an excuse because that wasn't the first reason that he told me that he pulled me over. It wasn't for window tint. And you can disclose that through the video of his own body cam. They said that they pulled me over because he presumed that I was trying to turn around in the parking lot or evade him, but I was door dashing like I told the officer that pulled me over before.
So, Deputy Sims, I believe when you testified a moment ago, you said you had noticed the window tint. Did you want to respond to that to me, please?
I guess, what are you asking?
You had stated that you initiated the stop, or at least you started to initiate the stop based on observing window tint. Is that correct?
So, yeah, I mean, I was with my partner. So there's also the part of he came off of Holmes Road, if I remember correctly, turned right into the parking lot, and then cut through the parking lot to go back onto Holmes Road. It didn't seem like there was any intention of him trying to stop at the store or anything like that. So he's also cutting through the parking lot.
May I add?
You may.
I did not try to cut through the parking lot, as I mentioned before, and prove to the officer before I was door dashing. And if I would have been on my phone, then he would have tried to get me for that as well. So I safely pulled over to where I could view where I was. And it was his presumption that I was trying to turn around in the parking lot, but my car wasn't parked.
That brings us to the end of the video. Honestly, he seems young and shows signs of being fairly smart, which makes you hope he'll learn from this and head in a better direction. Right now, this country needs more young people making positive contributions, not getting caught up in unhelpful legal theories. With better choices, he could avoid a lot of unnecessary trouble. Up next, we're moving on to a case from Wisconsin involving someone who ignored his court date. He thought returning to court was optional. Turns out it wasn't, and now he has to deal with the consequences. His future hearings will be far less comfortable because of that decision.
So the court is ready to make a decision in this matter. So in regards to the B ticket, that is the equipment violation, basically having obstructed vision with window tint. At this point, the court is finding you not responsible for the window tint, Mr. Smith, because based on just the testimony today, I don't think there's enough established to confirm whether or not the window tint would have been in violation. Now, regarding the A citation, that being the failure to disclose the CPL, the court is finding you responsible in that matter. And that is, again, based on MCL 28.425F. Basically, an individual licensed under this act to carry a concealed pistol and who is carrying a concealed pistol and who is stopped by a peace officer shall immediately disclose to the peace officer that he or she is carrying a pistol concealed upon your person or in your vehicle.
May I add, please?
Well, no, because at this point I'm making my ruling, and the pistol was in the vehicle. I understand it doesn't sound like you were in the vehicle at this point, but you were engaged with the officer, and it was your responsibility as the person with the CPL to immediately disclose that you had a CPL and that there was a weapon in the vehicle. So you are being found responsible. Again, this is a civil infraction for a first offense. There's a fine here of $500, and your license to carry concealed is being suspended for 6 months. Now, what I am going to say is that you do have the right to appeal my decision as the magistrate. If you do so within the next 7 days, the case will be reheard by the judge. So,
How do I appeal?
you would have to either consult with an attorney or you can talk to the clerks about getting the paperwork. I cannot give you legal advice. So,
Yeah, because I wasn't, as he stated before, sorry, I wasn't actually engaged in a traffic stop. That was the problem. I got
At this point, the court has made its ruling. This hearing is concluded. I believe that concludes the docket this morning.
You mentioned something happening against your will, but that's not really accurate. You explained that a previous judge asked you direct questions, and you chose not to respond. That refusal is considered contempt of court, especially when it happens right in front of the judge. That alone can lead to your bond being revoked. In a situation like this, letting your public defender speak for you would be the smarter choice. Sometimes representing yourself only makes things worse. This case is a clear example of how missteps can add up quickly.
Call 24 CF 1527, State of Wisconsin versus Gregory Robinson for a bail hearing. Appearances.
ABA Cecilia Park.
Attorney Stan Woodard, Public Defender's Office, appearing on behalf of Mr. Robinson, who does appear by video from the Dane County Jail.
Why don't you speak on
I have a copy of the complaint in this matter.
It is a bail hearing. State's position on bail.
Thank you, Your Honor. The state is asking that the court increase cash bail in this case to the amount of $50,000 with all previous conditions to apply. The state is stipulating that any previously posted cash bail should apply to that amount. The defendant have already demonstrated an ability to post some amount of cash bail. He posted $3,000 in this case in late June. He then missed a court appearance. The court set cash bail at $7,500 while applying the previously posted $3,000 in August, and then reduced that amount back down to $3,000, applying the previous amount. So in essence, allowing the defendant's release after the remaining custody. That release was in September. Just 1 month later, he missed court again. He has been out in warrant status for months and had to be extradited here at no small cost from the state. So for this reason, I'm asking all the state's recommendation.
Attorney Woodard.
Objection, Your Honor. I'm pro se in my case, so I don't know why that gentleman is standing there. And I want to speak on my own behalf because I am pro se in this matter.
Hold on one second.
I have no objection, and that's how he wants to proceed. You're right, just so you know, you do indicate you do not want a public defender, and that's what I happen to be. So I'm happy to withdraw.
You say you want to be out of jail living your life, but your actions tell a different story. You skipped your court dates, refused to answer a judge's questions, and had to be brought into this hearing by force because you wouldn't take part willingly. When someone makes choices like that, the court has little reason to believe they'll follow the rules outside of custody. Based on everything you've done, it looks like the system is treating the situation exactly as it should. That's the end of the video, and if there are future updates, I'll share them. Thank you for watching, and don't forget to support the channel if you enjoy the content.